Now, good morning to everybody. All right. We have one case on the docket this morning, and that's case number 21-18-13, Public Supermarkets versus Tanya Molina. We're well aware that this is a personal injury case where the defense served identical deposition notices ducis tecum with identical topics requested for testimony and identical requests for documents. We understand that the topics that are an issue are topics 5 through 9 and number 11. If that's not correct, please correct us quickly. And as far as the documents that are at issue, it's document request number 7. And that's it with regard to that. We're going to want to know, at least I will, exactly how certiorari is available here to the appellant. And we're also obviously going to want to know how Worley does or does not apply. Typically, we reserve 5 minutes for rebuttal for the appellant. If you want something different, just let us know. And you've got a clock there in one of the window panes. If you seem to be ignoring that as your time's running out, I may prod you a little bit and let you know. So without any further ado, Ms. DeWolf, I believe you're up.
Thank you, Judge Edwards. Good morning. May it please the court. I'm Diane DeWolf for the petitioner Publix Supermarkets. 5 minutes for rebuttal is perfect. Thank you. Your Honors, as you said, Judge Edwards, this case concerns an order denying discovery as to an entire subject matter that Publix sought to explore during deposition testimony, and that is the potential financial bias on the part of the plaintiff's treating physicians. And Your Honor's potential bias goes to the heart of many other defenses, including credibility of the witnesses, liability, and ultimately damages. Now, certiorari is the proper method for challenging orders like this one that prohibit deposition testimony on an entire subject matter. And Publix has shown in this case all of the elements for certiorari review, including a departure from the essential requirements of law, causing material harm that cannot be remedied by an appeal. And I will get to those elements in just a moment, Your Honor, but I first wanted to point out that the only argument that plaintiffs made below was that all of this discovery and these topics to be covered were prohibited by Worley. Recently, however, as we pointed out in our reply brief, after the answer brief was filed, after the arguments were made below, the Florida Supreme Court came out with 2 opinions that affirmed and held Worley to its very narrow holding, which is what Publix has been maintaining from day one. And that holding is simply that Worley says the defense cannot ask a plaintiff whether he or she was referred to their treating providers by their law firm, because that implicates the attorney-client privilege. It does not hold, Your Honors, that relationship between a law firm and a treating provider is never discoverable. And that's where, Westlaw's pretty good, but once in a while, Westlaw gets it wrong. And if you look at the opinion and you look at it on Westlaw, you'll see that the very first holding and the very first head note are wrong, because they say that this relationship is not discoverable, and that's not what Worley says, as recently confirmed by its 2 recent opinions in Yukon and Dodson. But Your Honors, the trial courts are still confused. They're getting it wrong. They're running amok with Worley, as the trial court did in this case, and they're expanding it way beyond what the opinion holds. And this court needs to stop it.
Didn't they also argue here, the plaintiff below also argue that this was overly burdensome, irrelevant, financially burdensome? Weren't that additional objections that might be distinct from the Worley analysis?
Judge Shasta, no, I don't think they said that it was financially burdensome. I think at one point there was
page 21 of the appendix, these types of intrusive discovery requests, when directed to a treating physician, are unduly and financially burdensome and irrelevant and in violation of allowable discovery. And then they say furthermore and cite the Worley opinion. So that seems to me to be alleging 2 potential basis that would, and one of which would be separate from the Worley analysis. Do you think that's wrong?
Well, yes, Your Honor. One, because most everything here that we've saw are topics to discuss during deposition testimony, which can hardly be overly burdensome, asking and answering a question.
And sorry to
Worley-
clarify, I'm not asking whether it is in fact overly burdensome. What I'm getting at is that there could be this overly burdensome analysis that the trial judge considered. We don't know because there's not a lot of explanation in the order, and we also don't have a complete transcript. So when we're looking at certiorari, why is this not an issue for you all, that there's this potential second ground unrelated from Worley that might be clarified if there is a transcript?
Well, Your Honor, we do have a transcript from all of the plaintiff's arguments, and the only argument that the plaintiff made, he said at one point, yeah, this is overburdensome, this is, overbroad. There was no elaboration on that at all. There's no elaboration on that in the pleadings. And if you read the transcript, you will see that the only argument made was, I argued Worley from the trial court up to the 5th DCA, up to the Supreme Court. I have lived Worley for 7-8 years. I know what Worley says, and all of this is prohibited by Worley. That was the only argument made in the transcript. Your Honor, as you can see from the pleadings, it's very clear. Obviously a transcript of the second day of the hearings might be helpful, but it's not critical. Because we can see from the pleadings and from the discovery requested in this case that it is relevant, and it is.
Counsel, did the plaintiff put on any evidence or make any showing of burdensomeness or financial burdensomeness?
No, Your Honor, none at all.
Okay.
And again, and just to clarify what overburdensome is, to go to your question, Judge Sasso, in Worley, that was a second holding in Worley. The court found that it was overburdensome because it was going to take 200 hours for the law firm to produce all of this information that the law firm didn't keep in the regular course of business. So they were going to have to go back and create all this information. It was going to cost them $90,000, and the whole claim was only for $67,000. That's what overburdensome is. Here, we're just talking mostly about questions, topics to be covered in a deposition. The only production is one request for a 1099s for 3 years, for one 1099. 3 years.
Doesn't public counsel, doesn't public expect, when it's designated topics for discussion, if you will, that the witness should apprise himself or herself of that topic and the answers to some of the general questions?
I imagine so, Your Honor, and I think that's the reason why this was sent out in advance of the deposition in this case, was to say, here's the topics we want to talk about. But again, these are very, very general questions. And for example, topic number 5, percentage of practice of treating patients using LOPs in the past 3 years. Now, we know in Worley that was expressly allowed. Worley expressly said that bias can be shown by the percentage of patients treated under LOPs. Question number 6, same thing, percentage of practice treating patients involved in personal injury. That's exactly the same thing. So these are very general questions that have been expressly allowed by Worley. And yes, this is a departure, like, to get into the factors for certiorari review. This is a departure from the essential requirements of law. We know these questions based on Worley. We know bias is relevant and discoverable in every single case. We can tell on the face of the.
Can you address that kind of dovetails into irreparable harm, which would be jurisdictional? Can you discuss how, because the trial court's order does allow discovery as to bias to some extent, can you respond to the argument in the answer brief that just the fact that this is a degree of bias, that if you were entitled to the full range of questions that Publix proposed, is irreparable harm when we look at the standard as being, the type of limitation on discovery that would eviscerate Publix's defense? Publix is still able to explore bias So why isn't this more appropriate for a plenary appeal?
Your Honor, Judge Sasso, I would have to disagree with you. I think if you look at the topics to be covered and the subpoena ducis tecum that were allowed, every single one that would go to bias was sustained. Every single objection was sustained to every single topic that goes to bias. I don't agree that anything that has been allowed here will allow publics to establish their bias defense. And this is
I don't know that's accurate. I mean, they're allowing discovery on the letters of protection, and correct?
well, if you're talking about the first three topics to be covered in deposition, those are not an issue. The plaintiff and the defendant came to some sort of agreement on that. I'm not privy to what that agreement is. I just know that they came to some agreement. So, and also no, a letter of protection as to Tanya Molina would not show any relationship.
Oh, it wasn't just the one letter of protection. I think they were allowing discovery on, the medical providers, how many letters of protection, what percentage of their work, is covered by those cases.
No, Your Honor, that's one that was specifically disallowed. That was topic number 5. The percentage of practice treating patients using LOPs was sustained by the trial court. That's not allowed here, which is something that's expressly allowed by Worley. So no, it's not allowed. The percentage of practice treating patients involved in personal injury claims, that was sustained by the trial court as well. And I don't think any of them that are allowed will allow publics to establish this bias defense, and it won't be able to adequately defend this case as to liability or damages or credibility for that matter.
Does your argument turn on us agreeing with you that none of the discovery that's been permitted would be relevant to bias? Or if we disagree with you on that fact, do you think certiorari is still appropriate if it is merely the degree of bias with which the doctor might have?
Your Honor, I think that it's, I personally believe that it has disallowed everything to do with bias, but if this court believes that it's left a crack in the doorway here, I don't think that crack is big enough to survive certiorari review. And we have cited several cases on this. Sabel and Ruiz are two of those where the trial court, allowed discovery, but it allowed depositions, but it denied it on one particular subject area. In the Sabel case, the girlfriend was refused to testify about the former boyfriend's former drug use. In Ruiz, there was one particular subject matter that the physicians refused to testify about, and that was an autopsy report. The autopsy, there was a meeting that took place after the original autopsy report came out, and then there was a meeting of the physicians, and then there was a new autopsy report. And the widow sought to find out what happened at that meeting, and they refused to talk about it. And that's exactly this case, Your Honors. That's where certiorari is appropriate.
How is topic 9 not barred by Worley? I mean, that you're not asking for the referral of this particular client, but you're asking for referrals of all their clients, or however many clients they referred to these treaters.
Well, again, Your Honors, okay, Worley only said that asking a plaintiff about a specific referral by her attorney to the provider implicated the attorney-client privilege, okay? So this is asking how many numbers of patients have you sent? They're not asking for any names. They didn't ask for any particular cases. All they said was, how many have you referred? And that could be a percentage, that could be a number, that could be anything. That could be, well, all of our patients come from Morgan & Morgan. That could be maybe half, maybe no, we haven't gotten any patients from Morgan & Morgan in years, okay? This doesn't implicate the attorney-client privilege by any means, because it doesn't ask for any particulars for any particular referral at all.
Well, you attempt to read Worley very narrowly, but this you know, we teed up for the Supreme Court, you know, this issue of Worley, and gave this Supreme Court that hasn't been, you know, shy about reviewing precedent, and they elected not to do it. I don't know why we read Worley narrowly instead of reading it broadly, since the Florida Supreme Court declined the opportunity to scale back Worley.
Are you talking about the UCOM and Dodger opinions that it just released? So I think if you read those carefully, Judge Cohen, you'll see that the Supreme Court declined to expand Worley in those cases. In fact, it said, again, what Publix has been saying from day one. Worley simply says that you cannot ask a plaintiff whether he or she was referred to her.
Did you see the certified question?
Yes, I saw the certified question, and that was whether we should expand, whether Worley also will prohibit these questions from being asked of the defense counsel. And the court said, no, that's not what Worley holds. And, you know, Justice Polston is ready to overturn this opinion. And the per curiam said, this isn't our chance to overturn it. You know, we can't do that right now because we haven't been asked to, but we're certainly not going to say that it also applies to this, which I think would be expanding Worley to some extent.
Right, you're into your rebuttal time if you want to say that, or if you want to keep going, it's your time.
I am into my rebuttal. If you don't have any other questions at this time, I'll reserve the rest of my time.
All right, thank you. Ms. Norse.
Thank you, Your Honors. May it please the court, Kristen Norse of Kynes, Markman and Fellman, here on behalf of Tanya Molina. So I think the court has sort of zeroed in on I think the key issue here, and that is that we're here on certiorari review. And of course, our Constitution and our rules limit review of non-final orders to specific orders absent, you know, extraordinary circumstances. And the court's kind of noted them. One, the petitioner has to show that jurisdiction exists because there's no remedy on appeal. And in an order denying discovery, that means showing that the denied discovery will eviscerate a claim or defense. And two, that the court's order is not just an abuse of discretion, but actually a departure from the essential requirements of the law that causes a miscarriage of justice. And
what discovery that has been allowed permits Publix to explore the issue of a financial relationship between plaintiff's law firm and any of these providers?
So I think your Honor touched on it. It's topic 9, which specifically says they want to address as a topic items including but not limited to the number of referrals that they have received from Ms. Molina's law firm. So that is directly implicated in Worley.
Right. My question was, what discovery is permitted? Topic number 9 was sustained. They're not permitted to get that. So what discovery are they permitted to get in terms of showing a financial relationship between plaintiff's law firm and any of these providers?
So there were 2 requests that they made regarding that, and I would say that would be topic 9 and then discovery request 7. And they were not permitted either of those on the premise of Worley. This document request 7 also asks for like—
I'm sorry, so was the answer to Judge Edwards' question none?
Yes, of the 2 discovery requests that they asked regarding relationship, those were not permitted.
Okay, that's what I want to understand. That you're saying whatever they asked about the financial relationship has been prohibited. It's not fair game for discovery, correct?
Right, and specifically, I believe that's topic 9 and discovery request 7.
Okay, and when you look at the recent opinions from the Florida Supreme Court, they really do hone down very, very narrowly and say it's whether you're not allowed to ask whether plaintiff's law firm referred the plaintiff to the doctor. Correct?
I actually disagree with that. There's actually a part in Youngkin, I believe, where they do like Worley did. Worley starts out and it says the narrow conflict question presented is a conflict because one court has held you can't ask the plaintiff if they were referred by their lawyer, and the other court had held you could ask about that. And so the conflict question was that, but in Worley, the Supreme Court said, but to get to that question, we have to look at this law more generally on the discoverability of that relationship and whether Bosher should be extended to apply to those scenarios. And the court says we disagree with the reasoning of all those cases that had extended it at that point.
And the court just saying Youngkin that Worley didn't apply, that the lower court, the intermediate appellate court had determined that Worley didn't apply.
They
And that's
did.
why they were not going to be addressing it. So how do you extend Worley when the court specifically says Worley doesn't apply?
Right, and I'm not trying to extend Worley. My argument is that Worley does address the general relationship, and that Youngkin says not that Worley only decided that narrow relationship referral question, but they actually say in Youngkin, Worley addressed the narrowly framed certified conflict question, whether the attorney-client privilege protects a party from being required to disclose that his or attorney referred the party to a physician for treatment. That is obviously not the issue presented in this case, although Worley went beyond that narrow issue. So the Supreme Court didn't say in Dodgen or Youngkin that Worley didn't decide the broader issue of discoverability. It did. So these new cases don't say, oh no, Worley didn't decide anything but that narrow question.
Well, the only other issues that the Supreme Court said it was addressed in Worley was the burdensomeness, which, you know, if you're talking burdensomeness here, what proof was given to the trial court that the request or topics were unduly burdensome, either just inherently or financially? I didn't see that anywhere.
So there was not evidence of the financial burden that this would pose, but there was the arguments about the general scope of discovery constrained by the case law that discusses how these broad requests delving into finances of treating physicians or experts or et cetera is unduly burdensome. It seeks extensive discovery for what is really what they acknowledge boils down to a couple of lines at trial about, do you have an interest in this case? And that's something that
Right, but in Bosher, the Supreme Court went on and on about how you create false impressions when the financial relationships are unknown, and the lengthier and more extensive the financial relationship, the more important it is to be known and made known to the jury. Otherwise, the search for truth is hindered, you know, whether it's on one side or the other. I mean, the only basis for Worley is attorney-client privilege. They did find in that case, and there was proof offered, that it was unduly burdensome given the 200 hours, $90,000 on a case that supposedly was worth $67,000. No such proof was offered here, correct?
Correct. There was no proof on the cost of this. The arguments were about whether the burden that was being imposed, given the breadth of the discovery, was merited based on what could possibly be discovered under the facts here. And
we
I
have
think,
no idea what can be discovered.
well, we do know that what they were seeking was some very specific potential evidence of bias. And I do want to point out that the trial court here, when faced with a specific concern that Publix expressed, addressed that concern and granted discovery over Publix's objection. So, for example, the one concern that Publix specifically expressed was Ms. Molina had billed, her charges had been billed sometimes through health insurance and sometimes under an LOP, and that didn't make sense. And so over objection, the trial judge said, well, I'm going to let you ask, did they accept her health insurance? Do they accept health insurance, and what kinds? And should hers have been billed, or why wasn't it billed? And then what are the respective rates that you charge? So this doesn't eviscerate any opportunity of proving bias.
But that's not really addressing the issue of bias.
Right. That was addressing the issue that they raised as to reasonableness of charges. On the bias issue, again, I don't think that was eviscerated either, as has been pointed out. They get to ask about the LOP. They get to ask about, what the charges were. Is this
How is the LOP relevant to bias?
It tends to show, as the case law has said, and I think as we see it play out in trial testimony, that a doctor may only get paid if there's a recovery. And so maybe the doctor in this particular case might have an incentive to testify differently. So I think that's how the LOP typically plays out in the trial testimony. And that's available here. And then again, there's the evidence as to whether they intentionally billed under the LOP instead of health insurance, whether what these charges are do they look unreasonable? So there's been no evisceration of the opportunity to show bias. And there's no case.
How does request number 9 invade the attorney-client privilege of Ms. Molina? I mean, it asks for what's the relationship? I mean, if the doctor was whoever is the trial lawyer at Morgan & Morgan, if that was his brother, wouldn't that be discoverable? If the doctor had given money back and forth between plaintiff's lawyer, wouldn't that be discoverable? If there was, the example I think Judge Lambert gave in Youngkin, if 100 plaintiffs represented by Morgan & Morgan were sent to the same CME doctor, that's all discoverable and all the money is. But if Morgan & Morgan sent those same 100 people to the same treating doctors, that's not discoverable. And they're both investigating the financial bias.
Okay, so I think your question sort of touches on two things. One is the uneven playing field that has troubled. I know you've talked about that example before. And that uneven playing field, what ultimately Dodgen and Youngkin even alludes to is there's difference. This is what Worley found. There's a fundamental difference between the relationship because of the attorney.
In what other circumstances does a lawyer get to choose fact witnesses? I mean, essentially, if a referral is made, I mean, you're talking about legal advice. The legal advice has to be, whether it's plaintiff or defendant. For a plaintiff, you should go to this doctor because it will benefit your litigation for a number of reasons. Many of them perfectly good. This is a very good doctor. He'll get you well. He'll testify. Some doctors won't testify. He can teach the jury what's wrong with you. Same thing with the defendant. When they're choosing a CME doctor, they go to that doctor because many of them won't testify, don't want to get involved in litigation. Some of them are very eloquent and good teachers, and some of them aren't. Those are all very good reasons, that can be given, and it's legal advice to your client, whether you're on the plaintiff or defendant, isn't it?
I think maybe it is legal advice. It was then permitted in Bosher, so whether that was correctly decided. But you did ask me another question I do want to hit also, and that is, how does this question of generally how many people have you referred, how does that touch on the attorney-client privilege? And I think this is exactly what Worley understood, and what is important is if I want to, yes, it doesn't interfere on Molina's attorney-client privilege, but it's however many other clients have been referred that now is open up for discovery. And so that is precisely what Worley prohibits, the referral relationship, the actual referral. And so whether you're invading Ms. Molina's attorney-client privilege or any number of the other law firms' attorney-client privilege, it's still an invasion of the privilege. And how would that play out, I think, is important to think about. So at trial, they're not allowed, we know, to get into whether Ms. Molina was referred. Would they then be allowed to say, well, but there's been all these other people referred and then leave that question open to the jury? I mean, that wouldn't make sense. And it also prohibits the plaintiff from putting any evidence that is there in context. So maybe there's 20 referrals, but 19 were to a specific doctor who's the only person in the community who performs a specific surgery. There can't be any context because the law firm is going to be prohibited from getting into that. So once you start delving into—
I think you've responded to my question. On the document request number 7,
right.
How does that necessarily get into the attorney-client privilege at all there? I mean, if assume there's no financial relationship between the plaintiff's firm and the treating doctor. If the plaintiff prevails and the doctor has unpaid bills, then the doctor is going to get paid. So that money would flow through. How is that not permitted to be shown that these providers have gotten whatever, $1 jillion or $10 through being involved in litigation with Morgan and Morgan as a plaintiff's lawyer? How does that invade the attorney-client privilege?
I think it has, again, the potential to invade the attorney-client privilege, although facially it may not. But when those 1099s are produced, then how do we place them in context? Were those referrals? Were those expert witness fees? How do we place them in context? That's what may infringe on attorney-client privilege. And of course, those types of document requests for 1099s and the actual financial information are what even Bosher prohibits under the law that existed even before Bosher, that you're not going to be able to get into non-parties' personal finances unless you can show a compelling or unusual circumstance. So again, this is
a 1099 doesn't get into the person's business in terms of how much money the business made, whether it's profitable, how much salary they take, and all the rest of it, is it?
It gets into the money that they're making from one source. And again, then there's the context, right? So if the defense is going to ask, well, how much do you make from this? Well, is that in a practice that makes 5 million and you've made 50? Does that make a difference? I mean, again, once you get into these, you get into context. And I think what all of these cases really come down to is we're looking point by point at all these different interests that are involved, the interest in efficient litigation, but also the interest in fair litigation. We're looking at the cost and the delay and what this is going to do to affect third parties, whether they be experts who shouldn't have to have everything opened up, or whether they be treating physicians who just happened into the case through treatment, or maybe they're orthopedic surgeons who regularly treat injury patients. We have to balance all those interests, and we leave that in the hands of the discretion of the trial judge. And I think we do that for a reason, because they're in the best position to know this case, to know what's the likelihood, given the scope of this case, what's the likelihood that this is going to lead to discoverable and admissible information. And
can I ask quickly, do you agree with Mr. Wolf that the second part of the argument has nothing relevant to, or would not reveal anything relevant to the kind of overburdensome, overbroad objections that accompanied the objections under Worley?
I think, are you asking me if we did object beyond Worley?
Just is the first portion of the transcript sufficient to address the overbreadth objection?
Right. It is not sufficient to address the first portion of the transcript. First of all, I don't know that it includes all of plaintiff's counsel's argument, because he ran out of time and it got cut off and the judge rescheduled. So we don't know what's in that second one. And we don't know what the judge might have had as far as back and forth with the attorneys. That doesn't necessarily impede review, which is really the test here anyways. But certainly to say that we didn't argue things when we don't have a transcript. And then again, we did argue them, I think, as Judge Sasso, you pointed out, in both our objection and our motion for protective order, we argued it was not likely to lead to the discovery of admissible evidence, and that it was beyond the scope of traditional discovery, and caused an undue burden. When we look at the certiorari jurisdiction, it's pretty clearly constrained in the case law. The order denying discovery has to eviscerate a claim or defense. And Publix has not said that a claim or defense is eviscerated, it said bias. As I've mentioned, I don't think that this request allows bias discovery. These are allowed bias discovery, they're allowed other discovery. This is merely a limitation on scope. And the cases consistently hold that orders that deny bias discovery actually are not subject to certiorari review, because you can remedy them on final appeal. If this case proceeds to trial.
Let me go run through some of the other topics real quickly with you.
Sure.
Do you agree that number 5, percentage of practice treating patients using LOPs in the past 3 years does not invade attorney-client privilege?
I agree. It does not invade I don't know. I think it might implicate that, depending on if you had to get into the context.
Okay, on number 6, for topic number 6, percentage of practice treating patients involved in personal injury claims / lawsuits in the past 3 years. Do you agree that does not invade the attorney-client privilege?
Again, I don't believe facially it appears to. I don't know if you had to dig in whether it would, but
All right. Number 7, information as to how you seek recompense, if at all, from LOP patients if the patient does not recover any and/or a sufficient amount to pay the LOP at the conclusion of the civil matter. Do you agree that that does not invade the attorney-client privilege?
I don't think it invades attorney-client privilege. I do think that other case law suggests that that should not be discoverable, and I'm really having a hard time connecting to that to relevancy of any admissible evidence.
Okay, number 8, as far as statistics of your percentage-wise, how much you collect on average on LOP amounts over the last 3 years. Do you agree that does not invade the attorney-client privilege?
I agree that that does not, but that also exceeds the scope of traditionally allowed discovery.
All right, and topic number 11, the relationship, if any, between medical providers and facilities involved in Tanya Molina's treatment. In other words, does one doctor have a referring relationship with another, or does one doctor own a clinic or something like that? Do you agree that does not invade the attorney-client privilege?
That does not appear to invade the attorney-client privilege. I don't think there's law that says you're entitled to that information as a matter of right. And again, I think that the reason that we end up having to go through each of these single point by single point is because there were multiple objections raised, not just Worley. And that we have to then go through each. What does the law permit? What does it sometimes limit? And is this judge exercising reasonable discretion when he says, you know what, for the specific concerns you raised, I'm going to allow that discovery, but for the discovery that is wide reaching on the potential that you might discover something, I'm not going to let those overly burdensome requests.
And where are you coming up from that explanation? I didn't see that anywhere.
What explanation?
As though
Right.
the judge were explaining why he was letting some and not others.
Yeah, so he didn't, we don't know whether he explained or not, but he did go point by point, and based on the arguments that were presented, I think one can conclude that. And I see that I'm out of time. For these reasons, we'd ask that the petition for cert be dismissed or denied. Thank
Okay,
you.
thank you very much.
Thank
All
you.
right, Ms. DeWolf.
Sorry, I hid my mouse under my notebook. Your Honors, I think counsel has conceded at least one point here. Counsel has said that the only questions that would give us the information we want as to financial bias are in topic number 9 and production request number 7. Both of those were denied by the court, and counsel said those were where we sought to see these relationships. Further, Judge Edwards, I think you touched on something here that is not prohibited by any rule, and that is topic number 11, the relationship amongst these providers. Now, we have 5 medical providers here, all of who treated Ms. Molina, and we're not allowed to ask if they have any financial ties to each other. I mean, it's certainly relevant if Dr. A refers every single patient to Dr. B because they have a financial relationship or a financial interest in that business as well. And what if all of these patients see all 5 treating physicians all the time, regardless of what their medical condition is? Vasquez, this court's opinion in Vasquez is still good law. And the Florida Supreme Court recognized that when it decided Yonkin just recently. And Vasquez says that these relationships between all of these agents are discoverable. And Your Honors, we know right now, based on Worley, that financial bias is relevant and admissible in every single case. We know that it's a departure from the essential requirements of law because Worley has told us that these types of relationships and financial ties and financial bias is relevant and it's admissible. And so here we are. We have a departure from the essential requirements of law. This cannot be remedied on appeal. And this is Beakey, this is Seville, and this is the Ruiz case. And they've all said, when you eliminate a complete topic like this, as counsel has conceded, financial bias, all the questions we wanted to ask about financial bias, the court denied. When the court does that, and we can't seek any of that information, there is no way to correct that on appeal because we have no way of knowing what this information would have shown. We have no way of knowing how this would have affected the outcome of the case. And, you know, going one by one, as we just did, you know, topic 5 clearly is allowed by Worley because Worley said that you can show bias by showing the percentage of patients treated under LOPs. The same is true for topic 6. Information as to how you seek recompense from LOPs, it does show an incentive. It shows an incentive to inflate bills and to support unnecessary treatments, particularly if these medical providers have financial ties with one another.
I have a question for you. Given the law in Special versus West Boca Hospital, that it would be plaintiff's burden on appeal to show that if this was error in not permitting the discovery, it was harmless error. Why doesn't that give you an adequate remedy on appeal? I understand the expense of litigation, but for whatever the wisdom of our jurisprudence is, that doesn't matter. But why wouldn't that give you an adequate remedy on appeal?
Well, Your Honor, I sure, but you could say that this is, you know, harmful error, but which is what we're going to, you know, say on appeal, obviously, but we're not going to know what that information is. If we don't know what that information is, we have, you know, no
Right,
basis.
but the burden is, if the ruling is not changed below, and if you go to trial without being able to show this bias, you raise that as an issue on appeal, how can the plaintiff, if those areas were discoverable as you maintain, how would the plaintiff be able to show that that was harmless error, that it could not have impacted the verdict? And if that's the case,
I don't know
if that's the case, how is that not an adequate remedy?
I don't know how the plaintiff could show that it was not harmless error, Your Honor, because we don't know what this discovery would have.
If they can't, then you have an adequate remedy on plenary appeal.
Well, if you're talking about a completely new trial, I would have to disagree that that's an adequate remedy. Yeah, it's a remedy. Is it adequate? I don't know. A complete do-over when we know right this second that this is relevant information, Worley's told us it is, and it's reasonably calculated to lead to admissible evidence. I see my time is up. I'm happy to answer any further questions you have. And if not, we would ask this court to grant the writ and quash the order eliminating discovery on financial bias.
All right, thank you. Very well briefed and well argued, and we will be in recess.